can you see it? Streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Hey everybody, hello. Hi guys, it's Sylvia, infamous Sylvia it is. I am here because I didn't get an opportunity. Hold on a second, hold on. Let me get this. Oh, how did I get this thing up here? Oh, let's change it back. I'm back. I didn't get the opportunity to say hello earlier to everybody in the chat, so I'm gonna go take the time to say hello. Hey, C-Sheets. Hey, Serena. Hey, Jackie Beasley. Hey, Lavelle. What are you doing in here? Hey. Hey, Kimmy. Hey, Serena. Hey, Nosy Rosie. Hey, Crime Junkie. All right, guys. Hey, Ruby. I've been talking to somebody. I'll send you a message behind the scene who I've been talking to. Okay, Ruby? But anyway, guys, today we have I have some footage from today. Just gotta tell you that we're gonna figure out whether or not Mr. Steele, Iron Steel, can win this case. Yeah, send me a message and I'll because you know me, I forget, Ruby. You know me, I will forget. And when you send me a message, I'll be like, huh, what is she talking about? But anyway, send me a message now and I'll reply to it. But anyway, will Mr. Steele win this case? Will he be, because you know, so far every case that I've gone to, he has won. But this case here, it's a little bit. I'm gonna play the motion hearing, and you guys, you tell me, what do you think? So I'm gonna go ahead and get started now because it was a couple of hours. So we'll go ahead on and run the tape. Okay. All right, here we go. Okay, this is them get ready to give Mr. Steele's client a plea deal, and she rejected the plea deal. And listen what the plea deal is, and listen what they're going to give her if she is found guilty. Okay. They want to give her manslaughter, right? And this is what they were going to give her the amount of time. Hold on.
Years with 12 years to serve, but we might be agreeable to go to 10 years to serve at the very lowest.
So 10 years to serve. Manslaughter, 10 years to serve. Okay, that's what they're giving her. If she takes the plea deal, she's going to reject the plea deal.
Of the offer, and I just want to put that on the record. Is that right, Mr. Steele or Mr. Layton?
Yes, sir. Thank you so much. That is correct, Judge. If this is a national raffle trial hearing, I have conveyed that offer to Ms. Boles, and Ms. Boles has rejected the offer.
She rejects the offer.
I think it's incumbent as part of the Fry hearing to place the maximum possible exposure on the record. Count one, house murder. Defendant faces the maximum possible exposure of life without parole in the Georgia prison system.
Life without parole.
Count murder, the same, life without parole. Count three, aggravated assault. 20 years is the maximum statutory punishment. So the defendant's total exposure in the case is two life without paroles.
He's looking at 2 life without parole.
20 years consecutive.
Plus 20 years consecutive.
I'd ask if defense counsel concurs with that.
I do, and we've conveyed that potential to our client, Ms. Boles, and knowing all that, and knowing the state's offer, yet she's rejected the offer.
She rejects the offer.
What is the next motion the lawyers would like to address?
Now they're going to argue the motion. Mr. Steele, y'all.
In order to possibly save time on the motion, is I don't believe the defense should be able to present the motion and go forward on it. Defense file.
Okay, the prosecutor is arguing that this motion had already been settled back in 2025, but Mr. Steele is going to admit there was something he had omitted, and that's one of the reasons why he put it in, because he didn't put it in there before in the motion. He never mentioned anything about the way he's going to mention, okay?
Motion on November 8th of 2021, the defense filed a motion that was styled Jackson Ditto. Motion for Jackson Ditto hearing. Your Honor will remember it's been a while, but in January of 2025, this court conducted a hearing in open court with both the defendant, her counsel, and the state having the opportunity to be present in open court on the Jackson Ditto hearing. Many witnesses actually testified under oath at that hearing about the defendant's voluntary interview or interviews that she gave with law enforcement after her, both before and after, immediately prior to her arrest. Several witnesses testified about her waiver of her right to remain silent, her being advised for rights under Miranda versus Arizona prior to the interviews commencing. And there were many witnesses, just a lot of witnesses, half a dozen probably, that came before the court in January 2025 and gave testimony about her voluntariness and her willingness to give police interviews in this case. There will be evidence in the case starting June 15th. Anticipate those interviews to be admitted into evidence. The court issued an order after a hearing in open court on the merits of that motion. The court issued an order, and that order is dated January 21st, 2025. The court styled the order on pretrial motions, and the court rules as follows. Jackson versus Ditto motion. The court finds defendant's statements at issue were not custodial and or were made after being properly informed of her rights and waiving the right to remain silent. So that was the order of the court in January of 2025, and then suddenly, just before the motion's deadline in this case, defense filed another motion on April 29th, 2026. So right before the deadline for motions, the defense filed a motion styled motion to exclude all statements made by Ms. Boles to law enforcement on or about March 5th, 2020. So this motion that was filed on April 29th is concerning the exact same subject matter that was argued before the court in January of 2025. And I asked the court to deny the defense's ability to relitigate this issue under res judicata, and specifically I cite the court to Cooper versus State, 306 Georgia 164, 2019 decision that reads as follows in pertinent part.
Hold on a second.
It it is well settled that the Georgia doctrine of res judicata
Why does this thing keep stopping, y'all? I don't know why it keeps stopping.
precludes the relitigation
I don't know why it keeps stopping. Something going on. It keeps stopping.
of claims where the cause of action of the parties or their privies are identical, and the claim was previously adjudicated on the merits by a court of competent jurisdiction. So it is a mystery to me how you can go forward in open court with a hearing, a contested hearing with witnesses on Jackson Ditto, lose, and then come back with a motion to exclude statements. It's very important to note that this is not a situation for the court's information where discovery was provided after that Jackson Ditto, where discovery by the state was supplemented after that Jackson Ditto, something new was discovered or turned over to the defense, and that gave rise to this motion. It's not that kind of situation. Full discovery, or almost full discovery, there were some small supplements, but certainly the video that is at issue in this motion by the defense was turned over to the defense well prior to the argument of the Jackson Ditto. So I would ask Your Honor to rule that this can't be argued again and litigated again. We had people come in and testify under oath. They were subject to cross-examination, and they should not just be able to be argued and litigated again. It's been decided. Voluntariness of the statements, the defendant's right to remain silent, that is the issue that's decided under Jackson Ditto. It's the issues that the court specifically referenced.
Okay, what they're arguing is that she spoke and she stopped speaking, and Mr. Steele feels that she invoked her fifth by stopping speaking, and they saying no, she was read her Miranda rights, and she continued talking to the detectives. So that's the argument. Steele wants to suppress what she said during the interview. And because at one point she told them she's tired of this, she don't want to talk anymore, something like that. But they're saying that she was she continued, she was flustered, and then she continued talking. So they're gonna play the tape, and you guys gonna get a chance to hear what happened.
In its court. So it's the first time for me that I've ever seen a non-prevailing party just file another motion to try to relitigate.
Oh, I'm sorry. Those who are coming in who don't know about this case, I'm sorry, Crime Junkie. This is a case of, her name is Lacy Boles. Lacy Boles, back in 2019, called 911 and said her husband unalived himself. And so during COVID, they were not able to do all the forensics and stuff that they were doing. It was all held backed up because they weren't, going to do the things like they used to do, right? So when she called and said that her husband unalived himself, and then when they start doing the forensics and they find out it didn't match what they found out from the testing and reports and stuff like that. So they came back in May of 2020 and arrested her. And on May 29th, they arrested her, and they accused her of unaliving her husband. First, she said he unalived himself, and then they turned around and said, no, the stuff that they found was inconsistent to her story. So they said that she did it because it was just her, him, and the two kids that was in the house, the children. Okay. This happened on December 22nd, 2019. And she's out on bond. That's why she's dressed regular and stuff like that. She's out on bond. And they even have a petition for her to be put back in jail. She's been out for the past 7 years.
So I ask Your Honor not to allow it to go forward. Thank you.
All right, any response?
Yes. Good afternoon, Your Honor. I'm Brian Steele, along with the Honorable Raymond Lau, representing Ms. Boles, who's in your court.
Welcome.
appreciate, the district attorney's statements.
Mr. Steele's the only attorney that I know, somebody who can have SA charges, somebody who can have murder charges, and he still get them out on bond. There was 2 guys who had SA charges, and he gave him bond. Thank you, crime junkie. He got them bond. She's been out. She got her like $100,000 bond, and she got him out. He got her out.
So what's going to happen is, I missed it. So during a March 5th, 2020 interview of Ms. Boles, she specifically said this was not raised here on the board. It's on recording. It's at 28:40 on the 3rd recording, part 2. I have it here. I'd like to put it into the record. And I'm quoting, Ms. Boles is being interrogated by the officer, and states, and I'm quoting Your Honor, "I am done talking about it." Excuse me. The officer first states, "Are you sure there isn't anything you want to tell me?" Question mark. Ms. Boles says, "No, sir." The officer said, "Nothing?" Question mark. Ms. Boles says, "No, period. I've told you everything. More than once I have been in this room to tell you everything. I'm done talking about it, period."
Guess whose phone is going off? Her dad's phone. Her dad's phone kept going off in the courtroom. Now the deputy's gonna go back there and get him. Hold on.
The officer then says, "This is the first time you've talked to me about it." And Ms. Boles says, "You're right. I'm sorry, sir. No, I told you everything." The officer then leaves the room. Ms. Boles is in the room by herself. She asks permission to use the bathroom. She's actually, before that, Your Honor, Ms. Boles says, "Can I leave?" The officer says, "No." Leaves her room. Ms. Boles is in there for another several minutes. Ms. Boles then asks, "Can I use the restroom?" Through the closed door. She's allowed to go to the restroom. And then law enforcement officers at 4250, is now new Detective Hill, Hill. He comes into the room and he tells Ms. Boles that he needs to talk with her. He reinitiates the communication. It's not done by Ms. Boles. And then the officer starts talking about Ms. Boles, her background, how she was born, raised, the deceased, accusing Ms. Boles of not being truthful. Your Honor, I don't see race judicata having to bar this. A Jackson Dental hearing can be reviewed anytime. And if it's anything, it is totally deficient performance. I have no strategic reason not to raise this in this honorable court. You did not hear this. If I'm wrong, please correct me with the transcript, but you did not hear this part. I am not coming after the court. We did it on a different matter, that she was in custody, had a lawyer. Your Honor, the court found it different. This is during the interrogation of what I just said. I'd like to play it into the record. It's very short, and then have the court rule on whether you're going to hear it. But if you are going to hear it, I think that is an unequivocal statement that she is no longer interviewing with law enforcement, and she's clearly in custody because she asked, "Can I leave?" and she's told no.
That was the May 2020 interview?
No. March 5, 2020, at specifically, it's Division 3, Part 2, starts at 28 minutes, 40 seconds. Can I play it for the South Court?
He's gonna play it.
This is, and if the state needs to see it, we could use their equipment or whatever they want, but I believe that they're aware of speaking with them. Your Honor, this is going to be, Lacy Boles, I call it Lacy Boles interview part 3, excuse me, interview 3, part 2.
objection to this being entered in as evidence as part of the issue of whether or not the court is gonna allow this to be further argued. And then if the court allows it to be further argued, we may enter in the state's version of the entirety of the video or whatever, but because it's being played, I'd ask that it be entered as defense exhibit 1, for example.
I'll mark it number 1, and if the court reporter would like a thumb drive, whatever the court reporter wants to memorialize it. And I can put it in the entirety of the defense better. Kept those going?
Yes.
Just working. It's audio, video, Your Honor.
839.
Starting at 28:40. And this is in the, what I'll call interrogation. It's 28:36.
Y'all can hear this, right? Put a headphones, y'all, because I gotta put a headphones on.
Your Honor, when Ms. Boles asked, do I get to leave, it's at right before 29 minutes, it's now 29:41. And really, nothing goes on for another 11 minutes if I can fast forward it, otherwise I can play it for 11 minutes.
I mean, we stipulate that after that point, further interview commences and further responses are given. I don't see the relevance of playing those further responses and questions. We know that further interview commenced after that time. But the crux of it is whether or not she moved to right to remain silent at this point. All right. If that's able to be argued and considered.
It's, at 40, if I can proffer, but I can play it. Ms. Boles asked to use the restroom, she's talking hand time, can't leave the room, that's why I wanted to do that. And then at 42:50 is when a new detective Bill or Spell, reinitiates the interrogation. So,
Stipulate to all of that as being true.
okay, that's fine. Then I'm going to, and we'll make sure we get the court order. Today's date, Ms. Boles number 1. Shut it. If you're
You have AirPods on? It's all right, hold on a sec. I'm trying to see why I stopped playing. Hold on. Now this thing is acting up, y'all. The computer's acting up. Let's see. Hold on a second. Hold on a second. Let me take this off and come back. It's acting up. Hope it doesn't start again.
Yesterday afternoon is the first indication we had that anybody was in.
several minutes, Ms. Boles then asked, can I use the restroom through the closed door? She allowed to go to the restroom, and then law enforcement officers at 42:50 is then new Detective Hill H-I-L-L. He comes into the room and he tells Miss Boles that he needs to talk with her. He reinitiates the communication. It's not done by Miss Boles. And then the officer starts talking about Miss Boles, her background, how she was born, raised, the deceased, accusing Miss Boles of not being truthful. Your Honor, I don't see race judicata having to bar this. A Jackson Denham hearing can be reviewed anytime, and if it's anything, it is totally deficient performance. I have no strategic reason not to raise this in this honorable court. You did not hear this. If I'm wrong, please correct me with the transcript, but you did not hear this part. I am not coming at the court. We did it on a different matter, that she was in custody, had a lawyer. Your Honor, the court found different. This is during the interrogation of what I just said. I'd like to play it into the record. It's very short, and then have the court rule on whether you're going to hear it. But if you are going to hear it, I think there is an unequivocal statement that she is no longer interviewing with law enforcement, and she's clearly in custody because she asked her ID when she's told no.
That was the May 2020 interview?
No. March 5, 2020, at specifically, it's Division 3, Part 2, starts at 28 minutes, 40 seconds. Can I play it for the South of the court? This is, and if the state needs to see it, we could use their equipment, whatever they want, but I believe that they're aware of speaking with them. Your Honor, this is going to be, Lacy Boles, I call it Lacy Boles interview part 3, excuse me, interview 3, part 2 of the interview.
Could you just, mark it please with some kind of
Yes.
sticker, since it's gonna be entered in? We have no objection to this being entered in as evidence as part of the issue of whether or not the court is gonna allow this to be further argued. And then if the court allows it to be further argued, we may enter in the state's version of the entirety of the video or whatever, but because it's being played, I'd ask that it be entered as defense exhibit 1, for example.
I'll mark it number 1, and if the court reporter would like a thumb drive, whatever the court reporter wants to memorialize it. And I can put it in the entirety of the defense. Better. Can I play it now?
Yes.
It's audio, video, Your Honor. You want to see it? And I'm starting at 28:40. And this is in the, what I'll call interrogation. It's 28:36. Your Honor, when Ms. Boles asked, do I get to leave, it's right before 29 minutes, it's now 29:41. And really, nothing goes on for another 11 minutes if I can fast forward it, otherwise I can play it for
I mean, we stipulate that after that point, further interview commences and further responses are given. I don't see the relevance of playing those further responses and questions. We know that further interview commenced after that time. But the crux of it is whether or not she moved to right to remain silent at this point.
All right.
if that's able to be argued and considered.
It's, at 40, if I could profit, but I could play. Ms. Boles asked to use the restroom, she's talking hand time, can't leave the room, that's why I want to do that. And then at 42:50 is when a new Detective Hill or Spell.
Seems like it's a problem when it's playing on this thing here. Hold on. I'm gonna switch over to my laptop because it keeps stopping when I do it on this. For some strange reason it keeps stopping. I think it's this attachment that I have that's causing it to keep stopping. Because this computer don't have but my laptop has it on there. Hold on a second. I'm trying to. It keeps stopping it. Hold on a second. I guess after a while it has to catch up. Hold on, let me get my laptop. I'll play it from my laptop because it's a problem when it's playing it from this. I don't know why. Just bear with me, y'all. Let me just get my laptop. Hold on. It keeps stopping when I play it on. Because you know I have an attachment into this. Okay. Let me remove myself off of here and then go in. Okay, sorry about that, y'all. Sorry.
Yesterday afternoon, it's the first indication we had that anybody was interested in negotiating.
Days, and I'm quoting here, I am done talking about it. It is totally deficient performance. I have no strategic reason not to raise this in this honorable court. You did not hear this. If I'm wrong, please correct me with the transcript, but you did not hear this part. I am not coming after the court. We did it on a different matter, that she was in custody, had a lawyer, your honor, the court found it different. This is during the interrogation of what I just said. I'd like to play it into the record. It's very short. And then have the court rule on whether you're going to hear it. But if you are going to hear it, I think that it's an unequivocal statement that she is no longer interviewing with law enforcement, and she's clearly in custody because she asked her on leave when she's told no.
That was the May 2020 interview?
No. March 5, 2020, at specifically, it's Division 3, Part 2, starts at 28 minutes, 40 seconds. Kind of ready for this out of the court. This is, and if the state needs to see it, we could use their equipment, whatever they want, but I believe that they're aware of speaking with them. Your Honor, this is going to be, Lacy Boles, I call it Lacy Boles interview part 3. Ms. Boles asked, do I get to leave? It's right before 29 minutes, it's now 29:41. And really, nothing goes on for another 11 minutes if I can fast forward it, otherwise I can play it for
I mean, we stipulate that after that point, further interview commences and further responses are given. I don't see the relevance of playing those further responses and questions. We know that further interview commences after that time. But the crux of it is whether or not she would the right to remain silent at this point. All right. If that's able to be argued and considered.
It's at 40, if I could proffer, but I could play it. Ms. Boles asked to use the restroom, she's talking hand time, can't leave the room, that's why I want to do that. And then at 42:50 is when a new detective, Detective Hill or Spell, reinitiates the interrogation. So
Stipulate to all of that as being true.
okay, that's fine. Then I'm going to, and we'll make sure we get the court order. Today's date, Ms. Boles, no, we don't. Shut. If Your Honor needs to hear it again, though, I promise you, I quoted it accurately. It's the officer saying, I'm just, if you need it, again, are you sure there isn't anything you want to tell me? Ms. Boles answered, no, sir. The officer said, nothing. Ms. Boles said, no, I told you everything more than once. I've been in this room to tell you everything. I'm done talking about it. The officer said, this is the first time you've talked to me about it. Ms. Boles said, you're right. I'm sorry, sir. No, I've told you everything. And then the officer gets up to leave, and Ms. Boles asked, am I free to leave? And he said, no.
All right, well, let me look back, see if I can figure out what we heard last year. I'm looking at the motion for Jackson Denno hearing. Looks like about November of 21. Is that right?
This was filed in, Judge.
I have it as November 8th, 2021. The motion
Okay.
was filed, and then January 14th, 2025 was heard.
And then, yes, it's kind of hard for me to read that stamp, but that must be accurate. And in paragraph 1, the defendant alleges in this motion she was interrogated by law enforcement on several occasions, and multiple dates are listed, and one is March 5, 2020. And so we had a hearing, and I issued an order. And so it does seem to me like we've already had that hearing. I've already made a rule. And you're asking me, Mr. Steele, to hear it again.
Not accurately, no. I believe, and please check the memory and transcripts, but I believe I never raised this to your court. So I don't believe I properly tabled this issue. I think I missed, my memory is I missed this. I'm getting ready for trial. You see, I have a duty to raise it with the court. I believe it's an unequivocal statement of I'm done talking. That means that there should be no more interrogation by law enforcement. So if we go through the trial, and God forbid there's a conviction, I am stating for the record that I am deficient. There is no strategy in trying to get in the balance of her statements. So I'm trying to raise it now, which is what the courts want me to do, so I don't waste everybody's time. And I'm raising it now, and I think that it's a clear issue that, through no fault of the prosecution or your court, you did not hear it previously. But if I sit here and don't raise it to you, I think I'm not following what you're taught to do. I'm just
state is opposed to opening this issue up again in any way.
Can we have 5 minutes in light of Mr. Steele's deficient performance monologue?
Sure. I'll step down and y'all let me know when you're ready, okay?
Okay, Mr. Steele admit that he made a mistake, and so the prosecutor says since Mr. Steele had admitted that there was a mistake made on his part, that they needed him and his co-counsel needed to talk about that situation, and so therefore they went offline to talk about it. The judge gave them time to talk about it. Now we're going to go to the next one. This is when they come back.
This contention that this origin video was just missed the first time around, so we'll agree to take on the burden on behalf of the state to relitigate the issue.
And now, okay, now that the state admitted that Mr. Steele was right in regards to his error of not bringing it up, because now he want to perfect the records, because if it has to go to appeal, he want to make sure that he perfected and get that brought in. So now the state is saying, okay, Mr. Steele, you're right. Now, since we're not going to be using that, we're going to bring the individuals in who can testify to what actually happened. This is in Dallas, Georgia. This is in Dallas, Georgia, Big Ray. And this trial, Christine, this trial is about a wife that unalived her husband, but when it first happened, she said that he unalived himself. That's what this case is about.
The statement has concerns the 28 minutes and 40 seconds portion of the report.
All right, so based on that, I'll hear it. The question now is, where do we go from here? I've got the defendant's exhibit and evidence.
We've got witnesses ready to testify.
He's gonna bring the witnesses.
Okay, then I will rehear the motion in that case.
State calls Detective Nick Hardy, please.
Here they come. Here come his witnesses. That's the first detective that was on the case.
Raise your right hand while standing to prepare to receive an oath. You solemnly swear or affirm the new testimony you shall give in matter not pending before this court. State of Georgia versus Lacy Boles, case number 20 CR 001378 shall be the truth, the whole truth, and nothing but the true self. I do. You can have a seat, sir. Please spell court your name.
My name is Nicholas William Hardy.
Did you have an opportunity to work for Paulding County Sheriff's Office on about March 5th, 2020?
Okay, I just want to tell you guys, I just realized that where I was sitting at, it was not close to the mic. I do have a mic on my camera. What I'm going to do next time when I go to court, when the trial starts, I will sit closer. Hopefully, I'll have something where I probably would be able to live stream, okay? Because I have a standing Rule 22 in that courtroom. All right?
Death of Daniel Akers, did you have an opportunity to conduct an interview or interrogation with this suspect, this defendant, in this case, on about March 5th, 2020?
I did.
Can you tell the court where that interview took place?
It took place at the old Paulding County Sheriff's Office on Industrial Drive.
And were you a post-certified law enforcement officer or detective with the Paulding County Sheriff's Office at that time? Did you have arrest powers in the state of Georgia?
I did.
So at that time, it took place at the old Paulding County Sheriff's Office. You said, how did Ms. Boles get to that location, sir?
She was transported by myself and I believe Detective Whitpower at the time,
And you say transported to that location from what location, sir?
from her residence. on Brentwood.
83 Brigmill Court, Highway 30141.
Yes.
So can you tell the court just briefly the nature and circumstances of how she interacted with law enforcement prior to being transported to the sheriff's office?
Yes, she was transported, or we arrived on the scene to conduct a search warrant. I asked Ms. Bowles if she would come back to the sheriff's office with me.
direct her to come with you?
Yes.
Did you order her to come with you?
No, I asked her to come.
Okay. What did you say? Do you remember?
I said I needed to conduct an interview. I don't remember the exact verbiage, but I asked her if she would come with me.
And what was her response, please?
She agreed.
Was she in custody when she was transported?
No,
Was she in cuffs when she was transported?
no, she sat in the front seat of my car.
Was she under arrest when she was transported from her home to the sheriff's office?
No,
Would it be something typical for you to transport a person under arrest, a person being detained or in custody in the front seat of your car?
I have before, yes.
Is that the circumstance here? She was detained in custody or under arrest?
No, she was not under arrest.
All right, sir. And when she arrived at the Paulding County Sheriff's Office, inside the building, what part of the building did the interview take place?
It was our CID area,
Okay.
criminal investigations area.
Was there a door that was locked where she was locked in at any time during the interview?
No,
Was she ever asked to leave the interview room where she was denied the ability to do so?
no,
Was she provided with water?
yes, and coffee,
Was she provided with the opportunity to go to the restroom?
yes.
Was she provided with the opportunity to eat any food if she wanted to?
I believe I did ask her if she needed anything.
All right. At any time during the interview on March 5th, 2020, did she tell you she wanted an attorney?
No,
Did you execute Miranda form or have her execute Miranda form at that time?
I did in the beginning.
And I believe we've already entered that form into evidence on January 14, 2025. Do you remember testifying and talking about the execution of her Miranda rights on that date?
Yes.
Was it a written form that you showed to her and had her read?
Standard Paulding County Sheriff's Office Miranda form.
Okay, did it include her, did it have on it, did it include her right to remain silent?
Yes,
Her right to request an attorney prior to the interview, did it include that?
yes,
Did it include her right to stop the interview at any time and request an attorney at that point?
yes,
Did it tell her that she had a right to an attorney even if she could afford an attorney?
yes,
Did she execute the form in your presence?
yes,
Did she sign?
yes,
I believe that's already been entered into evidence, Your Honor, from the prior hearing. We would just adopt the same exhibit from the prior hearing.
Any objection? No. All right.
Sir, was that interview audio and video recorded?
it was.
Have you had an opportunity to review it many times since the date March 5th, 2020? Let me show you if I can approach opposing counsel and show what's been marked for identification purposes only as State's Exhibit 54. And I just happen to have it marked for trial. I think I'll relabel it and just mark it number 1 for the purposes of this motion. Let me just mark it State's Exhibit 1 for the purposes of this motion. I'll show opposing counsel what's been marked down and marked for identification purposes only as State's Exhibit 1. Yeah, defendant's Exhibit 1 and State's Exhibit 1 would be the same. I'm assuming there was only a small portion of defense Exhibit 1 played, but I do anticipate the entirety of the March 5th, 2020 interview as being contained on this State's Exhibit 1. Mr.
All right,
Brown?
you're tendering that?
Well, I'd approach, if I can approach. Do you recognize State's Exhibit 1?
Yes,
What is it?
it's a CD with the interview on it, it's got the case number on it and the date.
Have you had an opportunity to look at the disc in the interview prior to today?
Yes,
Did there any changes to the interview on this disc that make it somehow different or inaccurate from the original interview that you conducted and watched thereafter?
not that I'm aware of.
Any deletions, alterations, edits, anything like that made to the video that cause you to believe it's not an accurate depiction of the interview?
No,
You believe it's a true representation of the March 5th interview 2020 that you conducted this defendant at the Paulding County Sheriff's Office regarding the investigation into the death of Dan Ayers?
I do.
Move the court respectfully to admit into evidence what's been marked for identification purposes on the State's Exhibit 1.
I don't object at all for the purposes of this hearing. I just want the record to be clear. Would it be wise just to say then defendant's number 1, like the honorable prosecutor said, is assumed into stage 1 so we don't have different exhibits, or do you want 2 different exhibits?
They're both in, and if they're 2 copies of the same thing, I don't mind. Unless you have some other suggestion.
Yeah, I don't mind either. If we just make the record clear that defense 1, I trust the prosecutor obviously, so defense 1 is going to be identical portion consumed in stage 1.
Well, what you've tendered is, earlier is admitted, and S1 is, or stage 1 is admitted as
just the relevant portion.
I've been handed exhibits from the January 1425 hearings. I don't see a Miranda form.
There was a state's motion for the release of evidence, and that's why, because the Miranda form, that wasn't original, that was tendered in at the January 2025 motion, that was an original, that was tendered, and for the purposes of the trial, we would obviously need the original back, so we moved to have those returned, and I don't believe the defense objected to it, so then those exhibits were returned
Okay.
to the estate. But I'll seek to have my colleague find the exhibit here again, or a copy. Actually, I have it right here. This is, Your Honor, if I may approach opposing counsel, I'll mark this as State's Exhibit 2. And again, this is an original State's Exhibit 2, so if I can get it back for trial, just for the purposes of this motion, so the record is clear. This is State's Exhibit 2, but perhaps a copy could be made and mark it 2A. Just for the record of this motion, here, and approach opposing counsel.
Sure.
I'll show what's been marked for identification purposes now only as State's Exhibit 2. Yes, sir. Sir, let me show you what's been marked for identification purposes only now as State's Exhibit 2. I'll have you look at it, just look up when you finish, sir. Do you recognize State's Exhibit 2?
I do.
Just briefly, what do you know it to be?
Yeah, we have opposition.
Okay, we tender it without opposition, Judge. State's Exhibit 2 is a Miranda form executed by Ms. Boles on March 5th, 2020. Sir, do you know if that's, take a look at it now that it's been admitted, because it's only been admitted for authenticity and foundation, but what is,
It's our standard Paulding County Sheriff's rights and waiver form.
is that a form that you submitted and presented to this defendant on March 5th, 2020 in the interrogation room, or immediately prior to that?
It is.
Does it have a signature on it?
It does.
What does it say, if you can read it?
It says Lacy Boles, she signed there, then there's the date and time, and then there's my signature, my badge number, and then a witness, which would be,
Hey,
Sergeant
Kim.
at the time.
All right, sir. Take a look at this. Did the defendant ask you any questions before she executed the Miranda form?
No, I don't believe so.
In your recollection, did you attempt to explain it beyond what's on the four corners of the document, or go into it in something, did you add or subtract anything that's on that paper?
No.
All right, so did she sign it?
Yes.
Did you threaten her to sign it?
No.
Was she in custody when she signed it?
No.
Promise her any hope of benefit or reward to sign it?
No.
All right, I'm gonna have you look at a specific part of State's Exhibit 1 for purposes of this motion. Judge, I don't think my laptop's compatible with play the interview, but I'll get one brought up here just so I can play it. So, sir, do you remember, you and I have met before, we discussed this same issue, have we not?
We have.
And, is it true history that I brought to your attention, a point of 28 minutes and 40 seconds, as the defense attorney has since talked about this afternoon. We will review that.
Yes,
Did you have an opportunity to look at it?
I did.
And do you disagree with what Mr. Steele characterized or how he paraphrased or exactly? I think it's an exact quote, the way he exactly quoted the defendant's statements at 28:40, where she said, you asked her something like, is there anything else you want to tell me? You remember seeing it?
Yes.
She said, no, is that right?
Yes.
And then you asked her, are you sure? Something like that. You asked her again, something like that. You remember
Yes.
that? And you remember her saying, I told told this story before in this room before I'm done talking about it. You
Yes,
remember her
I
saying
remember.
something along those lines?
Yes, sir.
Did you interpret that to be a request for an attorney at that time?
No.
Did you interpret that to be a request that the interview stop at that
No.
time? Okay, why not?
Her emotions, we were talking, and she seemed to get upset, and then stopped.
Okay, what did you, when she said, I'm done talking about it, what did you, since you were there and you were talking to her in the interview, what did you consider it to be?
I'm going to object. It's memorialized on a recording that's audio and video. It's now, I guess, State's Exhibit number 1 at the time mark. The courts make these decisions. It's not for the officer's subjective interpretation. The courts make an objective de novo review because it is.
I understand that, but I'll.
All right, at this point, well, I'll ask you, since the question's been allowed, when she said, and I'm not asking you to quote the law or get into her mind, I'm asking you what you thought, what you interpreted her statement to be. Because that's what it issued here. So when she said, I'm done talking about it, what was it to you?
It was the incident involving her and her husband.
Okay. And if someone said, I'm done talking about it, why did you continue to conduct the interview and then encourage Ms. Detective Hill to conduct the interview after that?
Because I didn't believe she invoked her rights at that.
And did she say anything about an attorney the entire day with you?
No.
And then, in fact, we can watch it in a minute. I'm sorry for the technical problem, but when we can watch it when it gets up there, we will. But in fact, when she said, I'm done talking about it, did she then, in fact, continue to talk about it?
She did.
Okay. Did she ever say, for example, I told you I don't want to talk about it, or anything like that?
No.
Did she request an attorney at any time after saying, I'm done talking about it?
No.
If she had said, I'm through with this interview, or something along those lines, would you have interpreted that differently?
Yes.
How would you
I
interpret
would have
that?
ended the interview.
Okay.
Hold on, y'all. Let me go to get the next one.
I don't know anyone, and like I said, he told me long ago, and of course he already had the gun going towards his mouth when I tried to stop him, grab his arm.
And what she demonstrated to me.
All right, thank you. So, do you recognize the surrounding wall and the chair rail and things like the colors and things like this on the screen now when publicizing State's Exhibit 1?
I do.
What does that look like to you?
It's our interview room at the time at the school sheriff's office.
Okay, so do you have any doubt that this is the interview room that you utilized on March 5th, 2020?
No.
Do you recognize anybody in this photo?
Yes, Ms. Boles is right there, and I'm right there.
All right, so it's been such a long time ago now, 6 years ago. So does this appear to be the way that you appeared and the way she appeared at the sheriff's office on March 5th, 2020? 2739. I know Mr. Steele referenced 2840, but it's about as close as I can get it without
That's
saying
all I
all.
have.
I'll have you watch it.
Why would that not add up?
Because we're the balloon internet.
I don't know where the bull entered to, so that's just what, that's where it was, that's what happened. That is the truth.
I don't believe you. I'm sorry, I don't.
Okay? But that's the truth.
I'm really trying to help you, Lacy.
I
It's just
understand that.
looking right now.
Okay, well, I'm telling you the truth, so I'm not sure how it looks or what it looks like. To be honest, I've done nothing but tell the truth, and that's all I'm doing now.
I'm trying to give you an opportunity, to be honest with me, and we can get this all up and taken care of.
It should all be done taken care of anyways. My husband killed himself. I don't need any other opportunity. I'm telling you the truth.
Lacy, I just don't believe it.
I'm sorry that you don't believe it, but it is the truth.
Can't I think of anything here covered?
You sure there's not anything you want from me?
No, sir.
Nothing?
Nope. I told you everything. More than once have I been in this room to tell you everything. I'm done talking about
This is
it.
the first time you talked to me.
You're right. You're right. So, I'm sorry. No, I told you everything. Thank you. Do I need to leave?
Okay, at that point, was that before or after you administered the Miranda warning to this defendant? At this point,
I entered our issued Miranda in the very beginning, so yes,
this is after that.
it's that.
All right. And did you hear a statement just now about the defendant leaving the room?
Yes,
What did she say to you?
I heard, do I need to leave?
Do I need to leave? Because were you getting ready to leave?
Yes,
You're standing up. Where were you going?
I was gonna go confer with my supervision to see what other avenues we needed to go.
Okay, are you, at this point, intending to conduct further interviews after this yourself personally with this defendant?
No, I reached kind of a point where I wasn't getting anything different.
Okay. And it looks like you started kind of you could hear some shuffling and packing up your stuff maybe, is that what the shuffling was?
Yes, I'm getting my notes.
Okay, and then she said what?
Do I need to leave?
Do I need to leave, and what did you say?
I said, no, not right now.
Okay. Did she say, do I get to leave to you?
I heard I do not, or do I need to leave?
Did you hear that then, or are you hearing that now, or both?
Both.
Okay. If she had said, can I leave, or do I get to leave, what would you have done?
The same thing, can just hang tight for just a second.
Okay, and why is that?
Because I wanted to confer with my supervision, see where we needed to go at this point.
Okay.
See where we were at with the search warrant, see where everything was at.
Okay, and did you conduct personally any interviews with her subsequent to this point?
I believe I was in the room at some point, but I don't believe I actually interviewed her at any point.
Okay, who conducted the interviews, if any, occurred after this point?
It would have been Lieutenant Hill at the time.
Okay, all right. And right here at this point, then, did you in fact leave the room?
I did.
Okay, is there any interaction you had with the defendant after this point, in this part of the interview?
I believe I came back in there, she has to use the restroom, and I was working on getting her a female to take her to the restroom.
And we've stopped the video, I stopped at 29:36. Do you see a cup of, any kind of cup, a beverage cup in this still frame?
Yes,
Is that water that you gave her or allowed her to have a coffee?
I believe that's the coffee that we gave her when we first got there.
Okay. Now, it appeared that you said, I've never talked to you before. Is that what you said?
Yes,
Why? What do you mean when you say that? What did you mean?
I've never talked to her before about it.
Okay, so she said, I've been in this room, I've talked several times, and you said, I've never talked to you.
Yes,
Is that right? Okay. And then, Did you notice any demeanor change on the video in her? As you said, I've never talked to you.
Yeah, she apologized and kind of changed her emotions and seemed like we were ready to go again.
Okay, and did that behavior affect your decision making at all with regard to whether or not she had invoked her right to remain silent?
Yes.
Okay, did that decision making at all affect did that behavior affect your consideration as to whether or not she wanted an attorney by that statement?
Yes.
And what was your thought on that?
She was ready to continue with the interview.
And did she in fact continue?
Yes.
And when did Mike Hill come in after this point?
Yes.
Were you watching on closed circuit television when Mike Hill conducted the interview?
Yes, at some points, yes.
Okay, and then at any time, to your knowledge, was there another point where this defendant again reiterated, I told you I'm done talking, or I told Hardy I'm done talking, I told the bald guy I'm not saying anything else? Did anything like that happen?
No.
Okay. And just a moment, Your Honor. Yes. Did you talk at all, did you give any indication to this defendant when she made this March 5th, 2020 injury that if she did not talk to you, if she exercised her right to remain silent, if she exercised the right to an attorney, that there would be some detriment to her?
No.
Okay. Did you give her the slightest hope of benefit or reward or the slightest fear of injury if she did not talk to you or she exercised her right to remain, her right to an attorney?
No.
I believe that's all I have with permission of Your Honor. The defense, I'll just leave it up here in case they want to play.
That'd be fine, Cross.
Thank you.
Good to see you again, sir.
Yes, sir.
Hope you're well.
Yes, sir.
I just want to, the court's going to have this in evidence. Lacy Boles said, I'm quoting, "Do I get to leave?"
I heard, do I need to leave? That's what I heard.
Okay, I heard you say you hear it both ways.
No, I didn't say both those, sir. I said, I heard, do I need to leave?
Have you listened to this with headphones?
No.
And then your statement right after that was, no, hold tight, and that may not be a quote, but something to that effect.
Something to that effect, yes, sir.
Meaning, stating
Yes, sir.
she's not free to leave.
I needed her just hang tight so I could figure out what we need to go from there.
I understand, but she's not free to leave. At that point in time, she's not free to leave.
No.
That's my question, am I correct?
Yes.
Okay. And the Miranda rights form that is now I think it's number 2. States did number 2 for purposes of today's hearing. Says that she can stop the questioning at any time. Fair to say?
Yes.
I mean, that's the standard, right?
Yes, sir.
Okay, I'm gonna play it one more time. I know the judge doesn't need you and I to interpret it, I'm just gonna play it one more time. Just tell me if you hear it differently, okay? And I'm just talking about the, do I get to leave? Your Honor, may I do that?
Yes, sir.
May I touch your computer?
No, if you need any help, I'm gonna hit it, yeah. It's got the touchpad mouse.
Thank you, sir.
So
If you could just announce what time we're gonna do it. I guess go back, if you don't mind, to Lacy Boles saying something effective. No, I told you everything, just so it's in.
Yes, sir, it's hard to go back to a specific time mark, so I'll go back to 27:21, which is where it ended, and that'd be about a minute before that comes up. Just
Does not make sense either.
I don't know, but I'll do that. Thank you. This is as loud as I can get it, Judge, but Your Honor will have it back in chambers if you want to listen to it. And I'll start now at 27:28.
I don't know him, like I said, he already had the gun go, and of course he didn't. He already had the gun go towards his mouth when I tried to stop him and grab his arm.
And what you demonstrated to me does not add up,
Why would that not add up?
because when the balloon
To be honest, I've done nothing but tell the truth, and that's all I'm doing now.
I'm trying to give you an opportunity to be honest with me, and we can get this all up, taken care of.
It should all be done taken care of anyways. My husband killed himself. I don't need any other opportunity. I'm telling you the truth.
Lacy, I just don't believe it.
I'm sorry that you don't think everything is the truth.
Can't really think of anything deep covered.
Hey, Cam Cam.
Sure, there's not anything on time.
No, sir.
Nothing.
No, I told you everything. More than once have I been in this room to tell you everything. I'm done talking
This
about
is
it.
the first time you talked to me.
You're right. You're right, sir. I'm sorry. No, I told you everything. Thank you. Do I need to leave?
All right, stop at 2938 on State's Exhibit 1. Thank you.
You did hear also that Lacy Boles said, "I'm done talking about it," right?
Yes.
And you know that, and you said, I believe on direct, that was about the incident, about the shooting. the death.
Yes.
Okay. All right. Thank you, sir. Thank you, Your Honor.
All right, thank you. Anything else from the state for this witness?
Nothing further from this
All right,
witness.
thanks, sir. Step
Thank you,
down.
sir.
Give another witness.
Well, Judge, I could call other witnesses. They were called at the previous hearing. They would be able to go toward voluntariness of the statement. I'm not sure really that's what we're arguing about here. It seems we're arguing more about this specific statement being an invocation of the right to remain silent. If we're going toward the entirety of the Jackson Dinner arena, then I would call other witnesses to say that she wasn't pressured to speak, promised anything, or offered hope of reward benefit. It seems we're really talking about the invocation of the right to remain silent. If that's the case, then I won't call anybody else, but kind of just need some guidance from the court if the court's considering all of the issues regarding pre-arrest interviews, pre-arrest.
All right. Want to say anything about that, Mr. Steele?
Sure. We're not waiving anything, but Your Honor, we're not trying to relieve it. You rule, I understand. I miss this. This is the only section.
All right.
We need, so to me, it's a day note, this is my understanding of the law, it's a day note review by the salary court. It's on State's Exhibit number 1. You have the sections, I believe it's 2840, I think the state started 27, up to, I think you should listen to, up to 5250, it's already on there. And that's, you'll accomplish another like 10 minutes of Detective Hill there when he's telling, Lacy Boles she's not honest, and Detective Hill re-initiated the communication. But I agree, I'm not waiving anything, I'm not saying that your order is accurate, we're taking objection to your order, but no, we don't have to re-litigate that. It's just this new issue that I did not raise previously, but we don't need any.
Well, we'll call Linda Wicks for the purposes of what we're hearing today. State calls Linda Wicks. If you'll approach a witness stand, please remain standing to receive an oath. If you raise your right hand, please. You solemnly swear or affirm that any testimony you shall give in the matter not being before this court shall be the truth, all the truth, and nothing but the truth, so help you God. If you'll have a seat, please, you can lower your hand, state your name for the record.
Linda Wicks.
How were you employed in March 5th, 2020?
I was a sergeant in criminal investigations.
In Paulding County Sheriff's Office?
Yes, sir.
Were you a post-certified law enforcement officer as of that time with arrest powers in the state of Georgia?
Yes.
And you've seen what's been played on a screen here today in court, State's Exhibit 1. You recognize, if you'll look over your left shoulder, you recognize this environment on the screen?
I do.
You know what it is?
It's the interview room criminal investigations.
And do you know Detective Nick Hardy?
I do.
You see his head on the screen there?
Yes, sir.
And he was talking to somebody, it sounded like on the audio portion of the video here, he was talking to somebody. Do you know if that was you?
It was me.
Okay, were you in the same room at the time Detective Hardy conducted this interview?
Hold on, yeah, I'm trying to get the other one. Hold on. I had stepped away. Just 1 second, y'all. It's 179. I gotta see which one I missed out on. Hold on a second, guys. Which one is this? This is 180. I gotta go to 181. Hold on. 81.
It left later. Okay, did you interpret that as, how did you interpret her saying, I'm done talking about it? When she
It's the
said,
same objection. It's on audio and video. You've overruled the objection previously, but I'm making it again.
we have to inquire what was in the mind of the interviewer when we talk about why the right was not.
I understand what the legal standard is, but I'll let you ask the question.
How did you interpret it when she just gets exasperated kind of and says, I'm done talking about it? Was that an invocation of counsel to you? Or an invocation of the right to remain silent?
I didn't take it that way.
Why?
Just because she just got emotional, then she can't calm back down and seems to go further.
Okay. Did you make any promises to this defendant during this interview on March 5th?
I did
Promises
not.
about her case, how it would turn out?
No,
Did you make any slightest hope of benefit or reward to her if she talked to you that you would do something for her?
no,
Did you threaten her in any way, intimidate her to get her to talk to Nick Hardy and or yourself?
no,
Did you see him do any kind of things like that? Threats, intimidation, promises?
I did not.
Did you encourage this defendant to talk to you by saying, if you don't talk to us, in the inverse, if you don't talk to us, then bad things are going to happen, anything like that?
No,
All right. At any time during this interview with Detective Hardy, did you hear this defendant indicate that she wanted to stop the interview?
no,
Did you hear her at any time indicate that she wanted counsel during any portions of the interview? She
No.
wanted an attorney?
no,
And do you concur with Detective Hardy's statements under oath earlier that this defendant was provided with food if she wanted, snacks, coffee, water, restroom breaks, things like that?
yes,
Did you see her at any time shackled in this room,
No.
handcuffed?
no,
Was she under arrest at any time in this room during the interview up to the point where Nick Hardy left?
Now, this is all, the last question, especially for the court, I'm objecting again.
All right, so at any point was she detained or under arrest at this point during
This
this?
is a continuing objection.
no,
Thank you.
You object to that question?
Of course.
Did you hear her after, did you see Detective Hardy at any point kind of pack up some materials and get ready to leave?
did I see him pack up his?
Yeah, you look, it sounds like there's some
Yes,
shuffling on the
yes.
video, like he's getting ready to leave, like he's got
Yes.
maybe a notepad or something, and a pen or something, is that typical?
Yes, it is.
It looks like at some point he concurs with you on the video, did you hear that, said, do you have anything else, and you said no, do you remember that?
Yes, I do.
At that point, did you hear the defendant say something? talking about an issue here with what she said.
Which part?
Well, Mr. Steele contends, she said, do I get to leave? And Detective Hardy says,
You know, these are not only leading, this is, the best evidence rule has been applied by us. Of course, no ruling if it says another law. It's really not a good use of time. We object and ask for continuing objection. You have the evidence.
in response, I think it's a novel argument, not a good use of time when the defense is trying to relitigate this entire issue, but that's fine, Judge. Again, it's in the mind of the interviewer what they interpreted the defendant's statements to mean, her behavior, the totality of circumstances for this court to consider whether or not this was a direct and unequivocal invocation of the right to remain silent. It's in the mind of the interviewer. And this lady's liable to say, yeah, I knew she wanted a lawyer, I didn't care. I mean, if that's what she says, and that's important to the court, it's in the mind of the interviewer how it was interpreted and why.
I understand that the court is not in any way bound by a witness's subjective belief as to what, I understand that. I just don't see any harm in letting them ask the question. There's a new objection that I haven't heard before, which is best evidence. You care to respond to that?
Best evidence, it's still, there's been no evidence at this point. There's been no evidence from this witness as to what she interpreted this lady's comment, this defendant's comment to mean. And that's what I'm getting at. How did you interpret her comment?
I'm gonna let them ask the question.
So when she made a comment about leaving, what did you interpret that to mean?
We were both getting up to leave.
We being?
Nick Hardy and I
Okay.
were both getting up to leave the interview room, and I believe she was saying, do I need to leave too?
Okay. Was she, if both of you left, would she then have been alone in the room?
Yes.
Okay, all right. I don't have anything further. Thank you.
Cross.
No, sir.
All right, thank you very much, Mr. Davis.
We will invoke the rule if this is gonna continue though.
All right, do you have any other witnesses?
Yes, Your Honor, this is the last witness for this motion, but if the rules invoked, perhaps after the cessation of this motion, we'll instruct our other witnesses to remain outside. State calls Detective Mike Hill.
We'll invoke the rule for any motion, Your Honor.
All right. Any witnesses that are going to testify will need to remain outside and not let anybody tell you what's going on inside the courtroom until after we're done.
Hey, well, sir, if you remain standing and raise your right hand to receive an oath, you solemnly swear or affirm that any testimony you shall give tonight will not be before this court shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
You can lower your hand. See, please tell the court your name.
Yes, my name is Mike Hill, Hill.
Were you employed with the Paulding County Sheriff's Office on or about March 5th, 2020?
Yes.
What capacity?
At that time, I was a lieutenant in the Criminal Investigations Division.
Did you have an opportunity to become involved in an investigation into the death of Daniel Akers on or about the first of the year of 2020?
Yes.
Paulding County Sheriff's Office.
Yes.
Did that investigation lead to a suspect being identified as this defendant?
Yes.
And did you have an opportunity to participate in an interview with this defendant at the Paulding County Sheriff's Office on or about March 5th, 2020?
Yes.
And you've been in the courtroom and watched the video up until this point, have you not?
I have.
Prior to the rule being invoked, and we're stopped, for example, at 29:38 on the video now. Did you come in at some point subsequent to that and interview this defendant as well?
I did.
Okay. For how long? If you had to estimate.
If I had to estimate, I think I went back in with Detective Hardy for around 40 to 45 minutes.
Okay. And you say you went back in with Detective Hardy and he testified previously, he was in and out, but were you the primary interviewer during this last part of the interview?
Yes.
All right. Were you present? Sometimes I guess you guys watch the video or watch the interview on closed circuit TV or something. Did you do that in this case?
I believe I did, for the sporadically.
For the first part, where Nick Hardy was in there and Linda Wicks was in there, were you watching at some points on TV while it's going on?
Yes.
And then at some point, did you join in the interview?
I did.
Did you watch the administration of the Miranda rights on video?
I did.
Okay, did you see State's Exhibit 2 being administered to this defendant? I'll let you look at it.
Yes.
First of all, does that look like the standard PCSO Miranda form from back around that era?
It is.
Okay, sir, have you seen it before take a look at it, do you think anything's been added or changed to the standard Miranda form that you would usually use around that time?
No, sir.
And did you see on video, closed circuit video, or internet video, or however y'all watched, did you see this defendant sign and execute that paper?
I did.
Was there some long discourse, or she had questions about it, or asked something about what it means, anything like that, or was it pretty standard?
No, once explained, the document was signed.
Did you see any coercion in achieving a signature on that paper, sir, on the part of law enforcement?
No.
Did you see any of the, and am I correct in saying you're kind of a supervisor at that point over the party and witness, is that right?
Yes, that is correct.
So as a supervisor and providing oversight, did you see?
I'm gonna vote best evidence rule. Also, every question is just a meeting. The prosecutor just proffer what he wants them to say if that's what we're gonna do. I don't believe any of this is material. I'm objecting to relevance, I'm objecting to beyond the scope of the motion we're hearing, I'm objecting to best evidence rule. Leaving.
All right, don't leave. He can ask the witness what he observed when the form was executed.
Sir, at any point when you were watching for closed circuit TV, tell the court about any coercion that you saw on the part of these
Best
officers.
evidence rule beyond the scope of this motion.
How is it best evidence rule? There's no evidence. There's been no evidence presented of this man watching a screen and what he observed. There's no such thing. He could have observed anything that wasn't talked about today, and that's what he needs to testify about, whatever that was. There's been no evidence, best or otherwise.
Well, I don't think it's beyond the scope of the hearing. The question is whether you probably freely and voluntarily made these statements. I think that's within the scope of the hearing, isn't it? He's describing her demeanor. I think that's within the scope of the hearing. Best evidence, I'm not quite sure I follow. Is there anything else about best evidence?
Best evidence is all this is on the recording. All this is recorded.
Yeah, the best evidence.
And it's evidence.
Judge, this defendant could have seen them beating this witness could have seen these law enforcement officers beating her with a rubber hose 5 minutes before the camera started. I'm talking about at any time, I said at any time did you see this happen?
All right, overruled.
At any time during your observation of the interview or involved with the case on March 5th, 2020, did you see your detectives that are under you, did you see them coerce this defendant into speaking?
No.
Did you see at any time anyone in law enforcement on March 5th, 2020 promise this defendant any hope, or give her any hope of benefit or reward in exchange for speaking to them?
No.
Did you see any officers or anybody else, any people in the public advise this defendant or threaten this defendant, hey, if you don't speak, there'll be a negative consequence? Did you see any of that?
No.
It related to this video or otherwise?
No,
Did you
sir.
see any of that?
No, sir.
And I guess what Mr. Steele's arguing about the best evidence, that the cameras were rolling here on State's Exhibit 1, but did you see at any time, when cameras may not have been rolling, did you see Detective Hardy, Wicks, or anybody else threaten this defendant or offer her a hope of benefit or reward for talking to you?
No.
Were you present watching the video, watching the interview when this exasperation was made of, I'm done talking about it? Did you see that on whatever you were watching? Do you remember?
I can't remember if I was watching that exact moment or not.
Okay, no problem. Did Detective Hardy give you any concerns or considerations or cautions when you walked into the interview room? Did he indicate to you at all, did anybody indicate to you, Wicks, Hardy, or otherwise, that, hey, by the way, she asked to stop? Did they say that?
No.
Did they indicate to you at all that she had asked for an attorney?
No.
So when you came into the interview room, what was your impression of why the interview was going to continue, if it was going to at all?
Relevance.
Any response?
Judge, the relevance is obvious. If this interviewing law enforcement officer was under the impression that an invocation had occurred, he wouldn't have continued with the interview.
made the objection again, the court has articulated its understanding of the law, but then it overrules the objection. I ask the court to again move this forward.
All right, well, it's my belief, as I articulated earlier, that it's the court is not bound by a witness's subjective belief as to whether or not the client intended to end the interview or freely and voluntarily consent to the interview. I'm just not sure it necessarily follows that the witness's opinion on that is irrelevant or is not admissible. Maybe it helps me, maybe it doesn't. I know I'm not bound to it. If you want to continue an objection as to the witness's subjective understanding what happened, yeah,
That's what I've asked for, a continuing objection.
yeah.
Sir, did you, observe this defendant to you personally when you conducted your portion of the interview? Did you, the 45 minutes you talked about, did you observe this defendant ask to stop the interview in performance? With you?
No,
Did you have this defendant, does she invoke the right to an attorney at any point with you when you went there?
towards the end of the session, she did mention an attorney, but there was no invocation.
Okay, what was that, mentioned about?
She made an inference or announced a question of, do I need an attorney?
Okay. All right, and what was your response to that?
I cannot answer that for you.
Did the interview end shortly after that?
Yes,
Okay, sir. How long was the passage of time between the time the interview ended with Nick Harvey till you came in?
That's the evidence rule.
Response?
Again, we don't know that the time that elapsed between those two points is on this video. We don't know that. And even if we did, I can ask a live witness what he believes the time was.
I agree, overruled.
How much time elapsed between the time Hardy left and when you came in?
minutes.
Just not, was it a long period of time?
No.
All right, sir. That's all I have. Thank you.
Any problems?
Good to see you again.
You do, sir.
Ms. Bowles was in an interrogation room. True.
In an interview room.
Okay. And you came into that room, correct?
Yes.
She did not call you in that room, correct?
Could you repeat the question, Counselor?
Yeah. She did not call you into that room, correct?
Correct.
And when you went in the room, you went in with another law enforcement officer, true?
True.
And that would be the gentleman who just testified, first witness in this case.
Yes.
Right. And then you started to ask questions of Ms. Bowles, true?
True.
And she answered your questions, right? Some.
Yes.
Thank you. Thank you very much.
Anything else? No, Your Honor. Thank you. Thank you, sir, for stepping out.
Thank you, Your Honor.
channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With minds by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign and joys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign and joy is what we'll gain. We're a family, not just a show. Every click and comment